Friends, yesterday the Supreme Court of India delivered the correctness of the judgment in the very famous reservations case, reservation for promotions to SCs and STs, the very famous case called as M. Nagaraj versus Union of India 2006. Right. The Supreme Court, while disposing the SLP 30621 by 2011, in the case filed by Jarnail Singh and others versus Lakshmi Narayan Gupta and others, it has clearly stated that there is no necessity to refer the case of M. Nagaraj versus of Union of India 2006 to the 7-member Constitution bench. That means the Supreme Court of India has clearly delivered judgment in this case. Right, friends? According to Article 16, Clause 4, Article 15 says about the untouchability, and Article 16 says that the state may exercise its powers to enhance the backwardness of the SC/STs by giving promotion, by giving reservations at the time of employment. So the SC/ST or BC people, SC/ST particularly, they can get reservations at the time of employment according to Article 16, Clause 4. Right. So actually, during the year 1951, in the case of that Champakam Dorai Rajan versus State of Madras, the Supreme Court opined that there should be no reservations. Everybody is equal in the eye of law. So, but particularly in public employment, there should be no reservation. Subsequently, so many developments. M.R. Balaji versus State of Mysore, then Supreme Court considered that there may be some reservations for the people, but it has given a cap of 50% only at the time of employment only. But the case of M.M. Thomas versus State of Kerala, then this has come, and there is a proposal for reservations in promotions also. This has been continuing, but during 1992, we are all well aware about the case of Indira Sahani versus Union of India 1992. It is otherwise called as Mandal case, since VP Singh brought the so-called concept of creamy layer for OBCs. So at the time there was much furore, and the Supreme Court of India has categorically stated there is no necessity for promotion in reservations as far as promotions are concerned. So to uplift the people, to get them onto the ladder, to get equality with the other caste, you are giving employment, reservations in employment. That itself is sufficient. So the Supreme Court of India has declared, but anyway, at that, by the time itself, during 1992, before 92 itself, so many people were given promotion. So Supreme Court has given a time period of 5 years. Now up to 1997, you can give promotions and you have to stop. Right? The governments have stopped issuing promotions in reservations from 1997 onwards. Later, during 2006, the present case, M. Nagaraj versus Union of India, in that case, the Supreme Court, basing on the Article 335 of the Constitution regarding overall efficiency, so they have formulated a 3-point formula to be. So 3-point formula, while giving reservations, the states should consider, number 1, backwardness of the castes. How the backwardness of the caste is identifiable? By taking a quantifiable data, basing on the census. So that's the first point. Second point, overall efficiency of the administration. According to Article 335, the efficiency should definitely improve. And the third point is inadequacy of the representation of SCs and SCs, because in public employment they should have their own quota. Suppose there was in M.M. Thomas case, there was a famous carry forward rule. Suppose if an SC person or ST person is not available for promotion, it should be stopped, it should be carried forward to the next year. That's also gone. But anyway, so this is an inadequacy of the representation. If these 3 points are fulfilled, then there is no doubt that reservations in promotions can be given. But actually, this acted as a caveat, and as such, no promotions were given right from 2007 onwards. But very recently, in the month of June, on 15th June 2018, the Attorney General K.K. Venugopal requested the Supreme Court of India, please allow the government to give promotions in reservations. Then Supreme Court said, the Supreme Court never barred anybody. The government, according to their procedure, they can give promotions. So then they started giving promotions. Now this Nagaraj case has been revisited, and now the Constitutional Bench has clearly stated that as regards the quantifiable data, the states are not bound to give any quantifiable data, because taking advantage of the quantifiable data, you cannot give promotions and reservations, which is actually absurd, because now if you want to get the census, you have to depend only on the 2001 census, because 2011, every 10 years the census will be taken. 2011 census itself is not ready, so you have to go back to 2001 census. So it is highly ridiculous. Therefore the quantifiable data matter is not at all necessary. Then regarding that Indira Sahani case, creamy layer concept, it has also been discussed. So some people, these petitioners stated that just like creamy layer OBC, other backward castes, there should be this reservation, the reservation should go